So good evening, everyone. My name is David Idelia. I'm the current president of the ACS chapter here at Maurer School of Law. Before we get started, I'd like to give a few acknowledgments. We have the Mayor of Bloomington, Mayor Hamilton, here today. We have former Bloomington Mayor, Mayor Tommy Allison here today. And I see some of my old professors from last year. Hello. And last but not least, I want to recognize Dawn Johnson, Professor Dawn Johnson, our ACS advisor. Without her, we're not able to put on great events like this here at Maurer and bring in great speakers like Mr. Potter today. If you're unfamiliar with our group, the American Constitution Society is the nation's leading progressive legal organization with over 200 student chapters and lawyer chapters spread across the nation. Originally formed as a progressive response after Supreme Court's Bush v. Gore decision, ACS was founded on the principle that the law should be a force to improve the lives of people. We also have some excellent events planned this semester that we hope you can enjoy. Actually, next week we have Regina LaBelle, the former Chief of Staff of the White House's Office of National Drug Control Policy and current Director of Georgetown's Law Public Policy Institute, coming to speak about the origins of the opioid epidemic and the ensuing litigation, the multi-district litigation against Purdue Pharmaceutical. There will also be an opportunity to have coffee with Ms. LaBelle prior to the event. She'll be meeting a handful of students from 10:40 to 11:40 a.m. So if you're interested, we ask you to please RSVP on CareerNet. Now it is my honor and pleasure to introduce Provost Lauren LaBelle. Provost LaBelle was named Provost at Indiana University Bloomington and Executive Vice President of Indiana University in 2012. She is also the Van Nolen Professor of Law in the Maurer School of Law, where she served as Dean from 2002 to 2011 and Associate Dean from 1991 to 2002. Provost LaBelle provides a vision and momentum for creating a welcoming, supportive, and inclusive environment here at IU. As Chief Academic Officer, she also provides academic leadership and support for faculty and students. Provost LaBelle received her JD from here, Maurer School of Law, and her BA from Auburn University. She's been a faculty member at Maurer since 1985. Her scholarly work focuses on the role of federal courts and addresses issues such as procedural reform and sovereign immunity. And I would be remiss if I didn't thank Provost LaBelle for her generosity, because without her help, we would not be able to put on a great reception after this and host great speakers like we have today. So without further ado, Provost LaBelle.
Well, thank you so much, David, and happy Constitution Day, everyone. Constitution Day was mandated in 2005 by an act of Congress, and I would be remiss if I didn't tell you there was some constitutional question about whether or not Congress actually had the power to require us all to do something to celebrate the Constitution once a year, particularly universities, but here we are, and happily so. To function, our Constitution relies on, it's premised on, a robust democracy. For most of our history, I would describe the franchise as like the Big Bang. Slow but expanding, slow but expanding. You know, this next year we'll be celebrating the centennial of the 19th Amendment, and it's moving to me to think that the 19th Amendment was passed the year my mother was born. So the franchise has been expanding for most of my life, fitfully, but I think it's fair to say there are a number of threats to democracy in the 21st century. The first is low voter turnout, and Indiana University is trying to do something about that. Thank you. IU has joined with our Big Ten peers for some years now in the Big Ten Voting Challenge. We like to be in a friendly competition with the rest of the Big Ten, particularly our neighbors right to the north, whose name I never mention in public addresses. on anything that we can, but particularly on this issue, because the Big Ten Voting Challenge is designed to help our students register to vote and overcome obstacles to voting. There are so many obstacles to voting if you are a first-time voter, and particularly if you're a first-time voter in a place far away from where you perhaps grew up. And so our goal with the Big Ten Voting Challenge is to make sure that those obstacles are removed for every student at Indiana University, and also, of course, that we kick Purdue's butt in this. That goes almost without saying. Last November, voter turnout in Monroe County was higher than the statewide average for the first time in decades, and I'd like to think that the Big Ten Voter Challenge had something to do with that. The second big set of issues that threaten our democracy, and thus our Constitution, revolve around voter suppression, voter dilution, and the role of money, particularly dark money, in elections. Here, today's guest has been just phenomenal. I remember the first time I saw Trevor Potter on the Colbert Report. Our hero, Stephen, had opened a super PAC called Shh, and through a series of blatant moves intended to demonstrate how easy it is to evade any regulation of money in politics, eventually laundered about $800,000 in donations right out of the super PAC and into his own pocket, and then, of course, onto charity, with the cheerfully candid legal advice of our charming and devastatingly disarming guest today. At every single term, Stephen Colbert was like a gleeful child who had gotten away with, well, everything. He is delightfully gobsmacked in every one of these segments by the transparent evadability of every potential legal roadblock to his acceptance and laundering of campaign donations. And the two of them, our guest today and Stephen Colbert, put on what I consider a series of brilliant classes in what is wrong with federal campaign laws as they relate to money. So I am delighted to have the opportunity. I'm not introducing our guest. That happy responsibility falls to someone else. But I do want to thank him for being here and thank the law school and the ACS for hosting this event. And I hope all of you will join me in the coming months in trying to assure that all of our IU students are registered to vote and are able to vote. You'll see tables all over campus. Please give those people who are manning the tables a pat on the back and encourage students to be engaged in the democratic process. Thank you so much.
Another VIP just entered the room. I would like to acknowledge the Dean of the Law School, Dean Austin Parrish, for being here today. It's now my pleasure to welcome and introduce Jim Allison, who will introduce tonight's esteemed speaker. Jim Allison is the co-founder of the local citizens group, Reverse Citizens United, along with his wife, former Bloomington Mayor Tommy Allison. Beginning even before the Supreme Court decided Citizens United, Jim and Tommy Allison have been hard at work educating and advocating in the community against the harms of corporate influence in our democracy. Welcome to the podium.
Thank you. Who remembers 2010? When the Supreme Court ruled in Citizens United versus Federal Election Commission? Yeah, you all remember that. Well, right away, right after that, some shell-shocked Bloomingtonians convened a public gathering at the county library to see how many cared about that and what we might do about it. That turnout produced an organization whose name pretty much says it all: Reverse Citizens United, Bloomington, Monroe County, a co-sponsor of this event. We're still dedicated to local action. We're still dedicated to public education. and we're still opposed to the anti-democratic thrust of this toxic 5-4 ruling, a ruling, by the way, in a suit initiated by none other than Terre Haute attorney James Bopp, who, I might say, you may not know this, very nearly became IU student body president way, way back in the day. Yes, he beat him. Paul Helmke, Paul, take a bow. Take a bow, Paul. He beat him. All right. Enough merriment. If you habitually attend Bloomington's 4th of July parade, as you all should, you cannot have missed our mascot, whose name is Octi. Octi is a giant black octopus, 8 feet tall, with 8 long arms, and Octi symbolizes the corporate grip on so many vital American institutions. Join us next year in the parade. River Citizens United will welcome you one and all as we march together against all that Octi stands for, and of course, against Octi's parent, which is Citizens United. Now, if anyone here in this room deserves an engraved invitation to join that next parade next summer, that would be our distinguished speaker, Mr. Trevor Potter. Mr. Potter holds a BA from Harvard, JD from the University of Virginia. He served as general counsel in John McCain's presidential campaigns. He's former Republican chairman of the Federal Election Commission. He's an ardent critic of unlimited corporate spending, dark money in politics, and the Supreme Court ruling in Citizens United versus FEC. He has served on the National Governing Board of National Common Cause. And most important, he's founder and president of a nonpartisan nonprofit called the Campaign Legal Center to protect and strengthen the U.S. democracy. Many of us will recall, along with you, his television appearance on the Colbert Report when he helped Colbert form a super PAC called, well, it's called various things, I guess. I know it as Americans for Better Tomorrow Tomorrow. But it was you may not know this, it was an educational tour de force, as you mentioned, it truly was. And you may not know this, for that tour de force, he won a well-deserved Peabody Award for excellence in broadcasting. That doesn't happen just every day. He has ample recognition from his peers. The American Bar Association has said of him, quote, hands down, one of the top lawyers in the country on the delicate intersection of politics, law, and money. And he's here to tell us today about, quote, constitutional challenges facing our democracy, the Roberts Court's wrong turns on campaign finance, gerrymandering, and voting rights. Mr. Potter.
Thank you all. Thank you, Jim, for that kind introduction. I, too, love the 4th of July. I'm odd enough that as a child in Illinois, I used to go down and hear the Declaration of Independence being read in its entirety on the 4th of July. It's a long document. So thank you for that kind introduction and your work with Reversing Citizens United. David, thank you very much. And ACS for sponsoring this event. It's a great pleasure to be here. And Provost Robel, I'm so happy to be reminded that you are part of the Big Ten Voter Challenge, which I've heard of and I think is just a important, impressive initiative. So good work on that. The Provost noted the great joy that many of us had with the Colbert Report. So I have to give you a consumer warning, which is discussing these topics is always a lot more fun when Stephen Colbert is in the room. Alas, we'll just have to do without him. As someone who grew up in the Midwest, it's really a great pleasure to be here. I've been to Indiana before, of course. I grew up across the border in Illinois, but I'd never been to Bloomington. As I walked through the gate, I was really struck by the woods in front of me, which I'm told are Dunn Woods. I hear there's a prairie there somewhere too. I feel very Midwestern as I look at all of that. It's quite different from the swamps in Washington, D.C. Now, some of you undoubtedly have been to those swamps and you've seen the amazing, impressive National Archives building, which is built on top of what was a tributary along the edge there of the mall. And if you've gone in, you have seen this sort of hollowed chamber with heavy glass, metal, glass-topped metal structures that I'm told go down into the ground at night. And in one of them, preserved in an airless chamber, is a copy of the United States Constitution. But that is not really what we're talking about today, the preserved document. What we're talking about is the real Constitution, which governs our politics and our legislators. And it is very much out in the world, changing and evolving over time. Today, as we celebrate Constitution Day, which I never did in law school and now I know why, it's important to discuss how and by whom our Constitution has been shaped over the 2 centuries since the Constitutional Convention in 1787. I'm going to focus on the democracy areas that I work on at the Campaign Legal Center, the ones that the provost, as it happens, laid out: campaign finance, redistricting, and voting rights. When we speak of the framers of our Constitution, there is a temptation to think of them only as the men in the room in Philadelphia in the summer of 1787. But that freeze frame historical image is dangerously inaccurate, even when brought to dazzling life on stage in Hamilton. Originalists and living constitutionalists can and frequently do disagree over what the men in the room, and they are men, of course, in there, in 1787 meant, but that picture leaves out all the other framers, particularly the post-Civil War reframers of 1865, 1868, and 1870, and then the 20th century framers of 1913, 1920, and 1971. The Constitution began as an agreement among the independent states of the American Confederation for a federated republic, and it has become, 232 years later, a very different compact that we Americans have with each other to live in a complex democracy. Today's document and its interpretation by the Supreme Court still embody tensions between the 1787 founders' concept of sovereign states and the later founders' vision of national norms and more direct democracy. It is an interesting fact that the 1787 Constitution did not include an affirmative right to vote. And a more interesting one, that the 2019 Constitution does not either. Despite that fact, a number of amendments to the Constitution have assumed a right to vote in the course of dramatically extending the voting franchise. These amendments forbid suffrage from being denied or abridged to certain named groups until almost all adult citizens are covered by these provisions. Democratic changes we have made to our system of government through constitutional amendments have included the abolition of slavery via the 13th Amendment in 1865, when enslaved people made up more than 10% of the population. The guarantee of citizenship to all persons born or naturalized in the United States, and a requirement that all citizens receive due process and equal protection of the laws in the 14th Amendment. The guarantee that the right of American citizens to vote, quote, shall not be denied or abridged on account of race, color, or previous condition of servitude. The 15th Amendment, the direct election of senators by the people of each state in the 17th Amendment in 1913, rather than by the state legislatures as the original founders had envisioned. The 19th Amendment created the greatest numerical expansion of American voters 100 years ago next year, when the Constitution was amended to ensure the right of all citizens to vote regardless of sex. Finally, the 26th Amendment was approved in 1971, allowing 18-year-olds to vote and leading to your local voter work. Many of these amendments included provisions giving Congress the power to enforce the amendment's provisions. This meant that Congress has also acted over time as a framer of our Constitution, not only sending these amendments to the states, but also enacting legislation defining what the rights are. For example, almost 100 years after the enactment of the 15th Amendment in 1870, Congress in 1965 passed the Voting Rights Act to enforce minorities' voting rights by prohibiting discriminatory voting practices such as literacy tests and giving the Department of Justice and the courts tools to ensure compliance. In this and many others, the justices who have served on the U.S. Supreme Court and interpreted the Constitution have also acted as framers, for better and also at times for worse. We think of the court getting it wrong in Plessy v. Ferguson in 1896, which upheld racial segregation laws in public facilities, but then getting it right and correcting that error in Brown v. Board of Education 6 decades later. If only it were days. But as I will explain in a moment, the court got it wrong again in interpreting the 15th Amendment as recently as this decade, when the court in 2013 invalidated a key section of the Voting Rights Act in the Shelby County case. We think of the court getting it wrong in Dred Scott in 1857, which excluded African Americans from the rights of citizenship under the Constitution. It took the 13th and 14th Amendments to correct this error. However, an increasingly conservative post-Civil War Supreme Court again got it wrong by taking a narrow view of these amendments, largely vitiating for many years their purpose of ensuring black citizens a full role in society and in elections. There are some provisions of the Constitution which have never changed. One of these is the First Amendment. What has changed is the Supreme Court's interpretation of it, most especially in its application to elections and to the regulation of money in politics. Due to recent changes of the composition of the court, a majority of justices now see the First Amendment as prohibiting much regulation of money in politics, and a huge majority of Americans therefore now see the court's decisions as allowing and encouraging corruption in elections and in legislating. A few poll numbers illustrate public dissatisfaction with this current campaign finance jurisprudence. Only 20% of Americans say they are satisfied with our current campaign finance system. 59% of our fellow Americans agree with the following statement: The political system is broken. We just need to start over. That's kind of a grim thought. Now, until the 20th century, there were no federal laws regulating the spending of money in federal elections. Starting in 1907, a series of restrictions on corporate and later union political contributions and spending in elections became law. These responded to the widespread perception that big corporate money, the octopus, and labor money was buying election results and legislation. These restrictions were largely not challenged on First Amendment grounds until after the passage of the Watergate reform laws, which created limits on individual and candidate contributions and expenditure limits to limit money in federal elections. This led to the seminal campaign finance case of Buckley v. Vallejo in 1976, beloved by every law school's Constitution law class. There, the Supreme Court found a constitutional distinction between contributions to candidates and expenditures. The court upheld limits on contributions to candidates and political parties, but it reasoned that direct expenditures by individuals that were independent of the candidates they supported were protected speech that could not be limited because there was no evidence that they would corrupt candidates. The court also held that expenditure limits capping how much candidates can spend in elections, limits that most other successful democracies have, unconstitutionally violate freedom of speech. The Buckley opinion regarded the danger of the appearance of corruption from large contributions and the resulting threat to public confidence as self-evident. It recognized a governmental interest in guarding against this appearance of corruption by limiting the size of contributions and other restrictions on money in politics. Decades later, in McConnell v. FEC, the legal challenge to the 2002 McCain-Feingold law, a 5-4 Supreme Court majority again reinforced this broad view of the government's authority to regulate money in politics to prevent corruption and the appearance of corruption. That majority wrote, Congress's legitimate interest extends beyond preventing simple cash for votes corruption to curbing undue influence on an office holder's judgment and the appearance of such influence. Now, the bad news is that this decision was 5-4, and Justice O'Connor was the key vote. She was then the only justice on the court who had ever held elective office. And I believe her firsthand understanding of campaigns and of the sausage making of the legislative process made her more likely to defer to the judgment of Congress on this issue. She understood the corrupting potential of large sums of money in campaigns and the corruption possible in the legislative process when legislators are raising money for themselves and their party at the same time that they are drafting and voting on laws affecting those large donors. Unfortunately, for us and the country, Justice O'Connor then retired to be replaced by Justice Alito, who had no comparable experience with elections and legislating, and it turns out a very different view of the Constitution. It is important to note that no justice on the current court has ever held elective public office, which may partially explain their campaign finance and election decisions. In Citizens United in 2010, the court, with 2 new justices, for the first time extended the Buckley decision's protection of independent spending to corporations. The Citizens United Court, in its 5-4 opinion authored by Justice Kennedy, held that, quote, ingratiation and access are not corruption, and the appearance of influence or access will not cause the electorate to lose faith in this democracy. This marked a 180-degree reversal of several decades of Supreme Court precedent. As recently as 1990, the court had rejected such a right for corporations in Austin v. Michigan Chamber of Commerce. The Citizens United conclusion is in tension with the Buckley Court's corruption rationale and what members of Congress have openly admitted, that those who contribute or spend have a greater effect on legislation. A Republican congressman from New York noted in 2017, when he was explaining why he felt he had to support the tax cut bill, my donors are basically saying, get it done or don't ever call me again. Since Citizens United in 2010, the court has continued on this new path and struck down other campaign finance laws, such as in Arizona Free Enterprise, the 2011 case striking down a key part of Arizona's public funding law. This was followed in 2014 by the McCutcheon case that struck down federal aggregate contribution limits that had been in effect since Watergate and which restricted the overall amount an individual could give in a single election cycle. One practice of the court's current anti-regulatory majority is to write opinions asserting that there will be little adverse effect to their striking down laws regulating money in politics. Unfortunately, those defensive rosy predictions usually prove wrong. Take, for instance, Justice Kennedy's statement in Citizens United that the appearance of the sale of influence or access will not cause the electorate to lose faith in this democracy. Here is what the public thinks today. 82% of Americans think that government is, quote, run by a few big interests looking out for themselves. Interestingly, in 1964, when this question was first asked, only 29% of Americans felt that way. Americans today believe by a nearly 2-to-1 margin, 64% to 36%, that their, quote, vote does not matter because of the influence that wealthy individuals and big corporations have on the electoral process. Another prediction of the courts that has proven spectacularly wrong is that all the new money that would pour into our election system after Citizens United would be fully disclosed. We often forget that the Citizens United decision actually had one good part. The court upheld and praised federal disclosure laws. In a section of the opinion joined by 7 other justices, Justice Kennedy wrote that through disclosure, citizens can see whether elected officials are in the pocket of so-called moneyed interests. However, Justice Kennedy himself later admitted at a talk at Harvard Law School that the disclosure he envisioned was, quote, not working the way it should, close quote. Indeed, it is not. The Citizens United decision, combined with the resulting creation of super PACs, none as benign as the Colbert super PAC, and the non-disclosed funding of social welfare 501c4 nonprofit corporations and other secret vehicles, and the legislative and regulatory lapses that followed, all helped usher in a new era of so-called dark money. Nonprofit groups that don't disclose their donors have reported spending $1 billion on federal elections since Citizens United. So much for knowing who is buying the public officials. Another result of Citizens United has been a tidal wave of, quote, outside spending that is in theory independent of candidates and parties, but is in reality anything but. Remember, Citizens United was built on the Supreme Court's view since the 1970s that political expenditures that are wholly and completely independent of candidates will not corrupt those candidates and parties. In Citizens United, the court extended this protection of independent speech to corporations, with Justice Kennedy saying, by definition, an independent expenditure is political speech presented to the electorate that is not coordinated with a candidate. Yet again, however, the theory, which is the constitutional basis for the entire Citizens United decision, is the opposite of our current reality. The court's majority has failed to understand the very real practical limits on enforcing the line that it has drawn between independent speech and coordinated speech. In the first presidential election after Citizens United, both parties' candidates had their super PACs. Everyone knew which was Romney's super PAC and which was Obama's. That's because each candidate announced them, met with their leadership and fundraisers, and thanked their donors. In 2016, we saw Carly Fiorina's super PAC called Carly for America to differentiate it from her campaign called Carly for President. It set up tables outside Fiorina's campaign events. There, they passed out Carly stickers, signs, and pro-Carly literature, all produced by the super PAC to pay the costs the campaign could not, using the super PAC funds raised in unlimited amounts. Jeb Bush avoided calling himself a candidate for most of the first year of his 2016 campaign in order that he could twist the law and raise funds for and control his super PAC, eventually installing his campaign manager in charge of its $100 million pot of money before declaring his candidacy and going his independent way. This sort of interweaving of candidates and supposedly wholly and completely independent super PACs with unlimited funding has now occurred in federal campaigns at every level, from Congress to the presidency. This renders candidate contribution limits effectively meaningless. The money is going into two different pockets of the same coat, controlled by the same candidate and her agents. The obvious question is, why is this happening? In complete violation of law and contrary to the Supreme Court's preconditions for independence in Citizens United. The first answer is that the court badly misjudged the way that politics works in practice and what conduct the American people would see as corrupt. The second answer is that the court misjudged the capacity and appetite of the federal regulatory system to require disclosure of the sources of contributions and to police the distinctions the Supreme Court had created between coordinated and independent expenditures. In the 2003 McConnell decision, the court said that coordination resulting from what it called a wink and a nod would not be independent. But winks and nods turn out to be very difficult to prohibit. The Supreme Court's campaign finance jurisprudence relies on the Federal Election Commission to administer its decision. But the court has little knowledge or concern for that agency's limitations. A cornerstone of the post-Watergate reforms, the FEC is tasked with administering and enforcing our nation's campaign finance laws. But for the last 10 years, the agency has failed repeatedly to enforce the law on the books and has failed to write new, sorely needed rules, especially concerning transparency and bogus independent spending groups. By law, the FEC cannot have more than 3 commissioners of a single party, and it needs a majority of the commission, 4 votes, to take any action. But for the last decade, it has been mired in 3-3 deadlocks. Not because the Democrats only want to enforce the law against Republicans and Republicans only against Democrats, but rather because the recent Republican commissioners have been ideologically opposed to enforcing the law against almost anyone. Another problem arose at the end of this August. As you may have seen, one of the remaining 4 commissioners resigned, leaving the commission with only 3 commissioners and therefore no quorum. This makes it impossible for it to administer our campaign finance laws. It cannot even meet. In sum, the First Amendment says nothing on its face about spending in federal elections. But that has not prevented some Supreme Court justices, a majority at the moment, from reading it to severely limit Congress's power to regulate campaign finance. Thus, the court has effectively amended the Constitution in terms of the regulation of campaign finance, and has done so contrary to laws approved by Congress and the President, without knowledge of how campaigns and campaign funding works in practice, and in direct tension with the views of a large majority of the public. This has all resulted in a system that no one would have designed and which lacks a functioning enforcement mechanism. This is not an acceptable place for our democracy to be. Now, the court's democracy failures are unfortunately not limited to campaign finance. The court's current majority has recently decided to ignore judicial precedent and deny judicial relief to those suffering deprivation of their democratic rights from admittedly partisan gerrymanders. I refer, of course, to Rucho v. Common Cause, the North Carolina redistricting case decided this June. The Campaign Legal Center represented the North Carolina League of Women Voters in that case. Gerrymandering, as you can see, dates back to the early 19th century, when Governor Elbridge Gerry of Massachusetts and the state legislature drew new districts for a state senate. A Massachusetts cartoonist depicted one of the districts as a salamander or gerrymander. It was attacked as wrong then, but today's gerrymander is worse by an order of magnitude due to 2 forces: the power of computers and the detailed available voter and consumer data, and the hyper-partisanship of many state legislatures. Back in 1812, Governor Gerry drew his map with a quill pen and possessed only general information about the overlap between the towns and voting patterns. Today's gerrymanders have access to enormous computing power and big data to the point where they know how almost every household on a block votes and can draw lines with great precision. Now, gerrymandering should not be a partisan subject because it is not unique to one party or the other. Republicans have gerrymandered in Wisconsin, North Carolina, and Pennsylvania recently. Democrats have gerrymandered in Maryland, Illinois, and Massachusetts. In Wisconsin, in 2011, Republican lawmakers gerrymandered the legislature so successfully that the next year, in the 2012 election, Republicans lost the election with only 49% of the statewide vote to the Democrats' 51%. But they won 61% of the seats in the legislature. This gerrymander was the subject of Gill v. Whitford, the gerrymandering case that the Campaign Legal Center argued in 2017 in the U.S. Supreme Court. The hope was that Justice Kennedy would agree that the Wisconsin legislature's actions were unconstitutional. Kennedy had been the swing vote in the court's earlier Veith case in 2004. There he had agreed that overly partisan gerrymandering was unconstitutional, but he had stated that a gerrymander could not be declared invalid by the courts until there was an objective standard to separate average redistricting from purely partisan redistricting. But at the end, in a 5-4 vote, the 2017 Wisconsin case was returned without decision to the lower court, asking it to determine first whether the plaintiffs had standing. Days after this punt, Justice Kennedy announced his retirement, and Justice Kavanaugh ended up sitting on the court in his stead. This past term, 2 more redistricting cases reached the Supreme Court. One involved a Republican gerrymander in North Carolina, and the other a Democratic gerrymander in Maryland. In both cases, the lower courts had found that the lines drawn were unconstitutional because they were extreme partisan gerrymanders. In both cases, the facts were largely undisputed by the time the Supreme Court heard argument. No one seriously questioned that these were partisan gerrymanders. Here, for example, is what one of the Republicans leading the redistricting effort in North Carolina admitted on the record when asked the question, "Why did you decide to draw a map with 10 Republican districts and 3 Democratic ones?" He responded, "Because I do not believe it is possible to draw a map with 11 Republicans and 2 Democrats." In Maryland, Republican plaintiffs were challenging a single district they argued were unconstitutionally gerrymandered by Democrats to defeat an incumbent Republican congressman. Democratic lawmakers and consultants created the state's congressional map behind closed doors, conceding that their express goal was to draw the map in a way that maximized the number of Democratic districts, and again, I quote from the record, to minimize the voice of the Republicans. In the next election, they succeeded. One of the state's 2 Republican members of Congress was defeated in his new district, into which the map makers had put tens of thousands of new Democratic voters. Thus, the question squarely before the Supreme Court last spring was whether these 2 admittedly partisan gerrymanders were so egregious that they violated the U.S. Constitution, as the lower courts had found. Unfortunately, the court this summer not only refused to rule the extreme Maryland and North Carolina maps unconstitutional, but it also changed its constitutional jurisprudence and said that partisan gerrymandering could never be challenged in the federal courts, no matter the facts of the case. I believe that Justice Kagan was right in her dissent when she said that this result was tragically wrong. It removed the possibility of federal judicial review, and with it, a key line of defense against extreme, out-of-control gerrymandering that in all likelihood will now only get worse. The majority opinion, authored by Chief Justice John Roberts, claimed that there was no justiciable standard by which federal courts could evaluate when map drawing had gone too far. This is despite all the evidence before the court to the contrary, and despite the multiple federal court decisions over the last few years that had identified such standards and methodically applied them. Again, taking a rosy view while delivering this blow to democracy, the court's majority opinion pointed to action by state legislatures or citizen initiatives as a possible fix for overly partisan gerrymanders. These are indeed still tools in some states, although only about half the states provide a legal avenue for such initiatives. CLC is now working with organizations in several of those states to draft ballot initiatives to create independent redistricting commissions in 2020. The problem is that after 2020, it is likely that almost every state that can adopt an independent commission through a ballot initiative will have done so or decided not to. The court also noted the possibility of challenges under state constitutions and congressional legislation under the Elections Clause of the Constitution. As you may have seen earlier this month, the North Carolina Supreme Court struck down legislative maps in that state, finding them extreme partisan gerrymanders under the state constitution. Most other challenges to gerrymanders under state constitutions will have to wait until after the 2020 census and the resulting redistricting for the next round of gerrymanders. CLC and other dedicated organizations will continue fighting gerrymanders wherever we can, a goal which poll after poll shows that the overwhelming majority of Americans support. But the Supreme Court's misguided decision this summer means that it will be a much more challenging fight than it should be. Finally, another challenge and another threat to our democracy is the intensified attack across the country on voting rights. We at the Campaign Legal Center believe that the government should facilitate citizens voting, from easy registration through to casting ballots. Unfortunately, there's another increasingly vocal camp that believes the opposite, that voting should be a restricted privilege, which should be made difficult so that only the right citizens will be able to jump through hoops to reach the ballot box. In each of these battles, the prevailing camp becomes a type of framer too, but to very different effects, whether to continue to expand the franchise or to restrict it. Martin Luther King famously said that the arc of the moral universe is long, but it bends toward justice. In the voting rights context, we assume that this means more people get to vote, as we move along that arc. For a while, this is what was happening in this country, with voting by persons of color, then direct citizen voting for senators, then votes for women, then voting rights for 18-year-olds. But today, some politicians are trying to restrict the voting pool to their partisan advantage, and to do so are working to exclude eligible voters from voting. Unfortunately, this was greatly facilitated by the Supreme Court in 2013, when it ruled 5-4 in its Shelby County decision that federal preclearance of changes in voting laws in states with histories of discriminatory voting practices is now unconstitutional. Preclearance was a key provision of the Voting Rights Act of 1965, reauthorized by Congress several times since that year. Most recently, it was reauthorized in 2006 after numerous congressional hearings. Like Citizens United in the campaign finance context and Rucho in the redistricting context, the Shelby County decision is one that I believe the court got gravely wrong. Now, this is what the 15th Amendment says. Please note the second provision of the amendment, an unambiguous grant of power to Congress to, quote, enforce this article by appropriate legislation. The 15th Amendment was ratified in 1870, but Congress had to pass the Voting Rights Act in 1965 to enforce it, in the face of a history of severely discriminatory laws and practices that prevented African Americans from voting in the post-Civil War, Jim Crow segregationist South. In the 1965 Voting Rights Act, Congress created a whole legal fabric to ensure African Americans could vote. As Justice Ginsburg put it in her Shelby County dissent, quote, the Voting Rights Act became one of the most consequential, efficacious, and amply justified exercises of federal legislative power in our nation's history. I believe this background is crucial to understanding how very wrong the court got it in Shelby County, when Chief Justice Roberts wrote this: not only do states retain sovereignty under the Constitution, there is also a fundamental principle of equal sovereignty among the states. Now, references to state sovereignty recall the language of the 1787 framers and the language used by the secessionists of 1861. However, such language would appear peculiar to the framers of the amendments of the 1860s, who had just fought and won a terribly bloody civil war to vindicate the proposition that states were not sovereign entities able to withdraw from the Union. The 15th Amendment was adopted at a time when southern states were still occupied by federal troops, required to enforce the rights of African Americans newly freed from slavery. During oral argument in this case, Justice Scalia, for his part, said that the overwhelming majorities by which Congress had passed the VRA's reauthorization in 2006 appeared to be, quote, attributable to a perpetuation of racial entitlement. These statements are extraordinary in light of the history of the 15th Amendment and its purpose, and of the Voting Rights Act. The court criticized Congress's fact-finding of continued threats to minority voting rights in covered jurisdiction, all the while giving no deference to the 15th Amendment's provision that specifically gives Congress the authority to enact legislation such as the Voting Rights Act. In doing so, Chief Justice Roberts effectively puts himself in the shoes of the framers of 1787, while ignoring the new constitutional balance between the federal government and the states in the area of voting created by the 15th Amendment. He wrote as if our Constitution's only framers were those of 1787. In order to get around the language of the 15th Amendment, he chooses to replace Congress's overwhelming reauthorization of the VRA with the Supreme Court's 5-4 judgment against it. It is as if the 15th Amendment said, Congress shall have the power to enforce this article, provided it adopts the same legislation that a majority of the Supreme Court would favor if they were in Congress. Predictably, unfortunately, since Shelby County, there have been a wave of state actions in the South designed to diminish minority voting. Examples have included the elimination of early Sunday voting in North Carolina, a day thought to promote minority participation, the closure of at least 868 polling locations in minority communities in southern counties previously covered by Section of the VRA, Section 5 of the VRA. It has included discriminatory photo ID laws in states such as Texas, a law which had actually been previously blocked by the Department of Justice under Section 5. These laws recognized select photo IDs as appropriate for proof of identity for voting, such as concealed weapons permits issued by the state of Texas. However, they did not recognize as sufficient to vote student IDs issued by state universities. I wonder who they were trying to stop voting. In Georgia, shortly before the 2018 election, the Secretary of State, who was also the Republican candidate for governor, running against an African-American woman, abruptly placed more than 50,000 voter registrations on hold, meaning they could not vote on Election Day. 70% of those belonged to African Americans. Each of these actions could have been prevented if Section 5 of the VRA was still in force. So, in conclusion, two words that everyone likes to hear. In conclusion, today's unfortunate reality is that this country has become increasingly polarized politically. This, of course, makes it exceedingly difficult to amend the Constitution by the required 2/3 majorities in Congress or to ratify it by the 3/4 of the states. And that means that when the court gets it wrong, as it did in Dred Scott and Plessy, and I would argue in Citizens United and Shelby County and Rucho, new constitutional amendments are unlikely. Instead, we have to rely on Congress to work around those decisions or on future and different majorities on the Supreme Court to recognize their error and reverse the court's decisions. The good news is that there is more energy around democracy issues than we've seen in a long time. And in poll after poll, voters overwhelmingly say that they want reform. And there are more organizations and more lawyers, like those at the Campaign Legal Center, whose missions are to protect and improve our democracy. Of course, Congress could step up and use its power as a framer. Earlier this year, we had a concrete example of the legislation that recent energy on democracy issues can translate into. The Democracy Reform Package introduced the first week of the new Congress, H.R. 1. A sweeping package, this legislation would go a long way toward addressing the problems I have discussed today. It addresses campaign finance disclosure, coordination, and the FEC's structure. It creates a new Section 5 of the Voting Rights Act to meet the Supreme Court's objections, and it requires states to adopt independent redistricting commissions. But H.R. 1 was drafted by the House Democratic leadership without Republican involvement. While I support the substance of each of these proposals, I think it is important to recognize that sustainable long-term reform, to say nothing of passage by the Senate, will require bipartisan action. CLC and other organizations are therefore working to obtain bipartisan support for proposals such as these. There is no one silver bullet, but many dedicated individuals and organizations are working to improve American democracy, consistent with the goals of all of our Constitution's framers. So I hope that all of you, especially those of you who are lawyers and aspiring lawyers, will work towards this end as well. Our democracy needs your help. Thank you.
So we have time for a few questions for Mr. Potter. Trevor and Mary right there with the mics are going to walk around. If you could just raise your hand if you have a question, and they'll give you a microphone.
This is a step beyond where you've gone, but I'm curious about your perspective. There was recently a 10th Circuit case on faithless electors, which, as I understand it, says members of the Electoral College can get there and vote for anybody they want to with no restriction available by state law. It's a matter of personal conscience, which further throws any effect of democracy on who our president's going to be. Have I got that wrong, please?
You don't have the 10th Circuit decision wrong. So this is a really interesting question. I occasionally talk about the Electoral College, and I start by saying that the Electoral College has worked the way the 1787 framers intended exactly twice. Those were the first and second elections of George Washington. And the reason that is because the framers' idea was, they talked about it being done, the election by Congress, they talked about it being done by voters in the states, and they decided that they would give the choice of the electors, choosing the electors, to the state legislatures, because they would select the brightest, most able, most respected citizens of their states who would then decide who was elected president. And the first time it was easy because everyone wanted George Washington. After that, almost immediately after Washington, we ended up with two competing political parties. And that meant the state legislatures stopped selecting people they thought would make an independent decision, and instead they selected electors who they knew would vote for their candidate, Jefferson or Adams, on down the line. So the idea that these electors were going to exercise independent judgment, which was the framers' idea, is gone. The problem is nobody amended that section of the Constitution. So it still says the legislatures will select the electors. It doesn't say anything about them being bound by what the legislature wants them to do. Over time, the legislatures then decided to defer to the citizens of that state as to which party's electors should be selected. So you end up with the Trump slate or the Clinton slate. But those are still individuals, and no one has gone in and said in the Constitution, and they shall vote according to the majority of their state. We don't have that piece of it. So there are two decisions now. One is out of the Washington State Supreme Court, which ruled the other way. It upheld a Washington law that said you can be removed as a legislator and you can be penalized as an elector if you don't vote the way you were committed to vote to, supporting the person on whose electoral slate you ran. So Washington says they can be bound. Many states have these laws that say they're bound. The 10th Circuit, applying a Colorado law, said actually that's not right. That's not in the Constitution. They're not bound according to the will of the founders in 1787, which I think is a completely fair reading of the intent of the founders in 1787. So the question, which is going to be really an interesting one of constitutional interpretation, is what do the framers think today, meaning what the 1787 founders designed hasn't been here for a long time. We have all these amendments that refer to the rights of voters. They presumably, when they vote, if they get the majority, they win the election, they are entitled to have those electors vote for the candidate they were pledged to. Do we have the original vision of the Electoral College, or do we have a more modern democracy where the voters have spoken and the electors should be carrying out their will? I mean, one way to fix it without getting into I think the much bigger question of should we have an electoral college in a world where we now have a direct democracy, which can result and has twice in this century with different results, with the voters saying one thing and the electors comprised differently saying something else. Even without getting to that fundamental question, you could amend the Constitution to say that the electors shall cast their votes the way the state casts their votes, i.e. removing the electors as individual actors. You don't even have to have electors. You could have an electoral college and say the state's votes are cast the way the legislature determines the state's voters actually voted, and you wouldn't have any people to have independent action and potentially go against the results of their state. But where we are is going to be an interesting question, and I'll just a little insight in this. There are actually some very skilled law professors who have been pushing these cases in the hopes that they would end up with the 10th Circuit decision contradicting the Washington decision in order to get this case to the Supreme Court. Because their view is if the Supreme Court says that the electors are independent free will operators, that will be the final nail in the coffin of the Electoral College, and the country will say, well, that's crazy, and they'll have to amend the Constitution and change the Electoral College. That's one possible outcome. The other possible outcome is the court says they're independent free will operators. There is no sufficient consensus to amend the Constitution, and we're stuck with that, which would be a really unhappy place, I think, to be. Imagine after the election, everyone lobbying the electors to get them to vote for somebody else, or the candidates taking the firstborn of the electors away to ensure that they do as they've said they're going to do. So, great question.
So you mentioned North Carolina, their Supreme Court under North Carolina's Constitution invalidating electoral maps. Similar thing happened in Pennsylvania, I believe, 2 years ago. So how do you assess the prospects? Is that the next frontier now that the federal courts are closed to gerrymandering claims? Do you see a real hope in a bunch of different states for advancing these arguments and advancing this anti-gerrymandering cause? I guess one concern I might have is that state Supreme Courts might be more likely to be seen as controlled by one party or the other, and so it leads to the perception this is just about if the Democrats control the Supreme Court, they're going to strike down the Republican maps and vice versa. But regardless of that, do you see some serious prospects for this work spreading out in the states?
Yeah, I think it's definitely an option. As you say, we've seen it in 2 states already, Pennsylvania and North Carolina. It obviously depends on what the state constitution says and how it's interpreted and whether it has been or can be read more broadly than the U.S. It depends on who's on the Supreme Court. You're absolutely right. North Carolina's court has a Democratic majority. A couple years ago, there was a ballot initiative in Illinois to have an independent redistricting commission, which the Illinois State Supreme Court, controlled by Democrats, declared was unconstitutional under the Illinois state constitution. So sure, when you get into state Supreme Courts, part of the question you go through is what's the jurisprudence? What's the makeup of the court? Whose gerrymander is it? Is the court controlled by the same party or the other party than the gerrymander? So I think you'll see some. I personally think there is more hope, first of all, in the states that don't already have independent commissions through ballot initiatives, for those states to do it if a state has the potential for a ballot initiative. As I said, fewer than half the states do. So that's one possibility. The other will be Congress doing something. I thought it was interesting that Roberts in his decision tried to pass that hot potato to Congress and said, Congress under its election power could mandate independent commissions, at least for congressional elections, query whether it could for legislative elections. So it is possible that Congress could do that, but both of these are frustratingly more difficult than having federal courts able to step in. And my own view is that there would not have been a flood of cases if federal courts had the ability, which they did until this June, to take cases of extreme gerrymandering, do their fact-finding, apply the standards that they were evolving, and say this is too extreme. What would practically have happened is that legislatures would know where the line is, and they would try to stop short of it. You wouldn't have that quote out of North Carolina, because they wouldn't be so stupid as to say that. And publicly, at least, and you have this battle in North Carolina now where the Supreme Court is saying you have to do your redistricting publicly, you can't use computers to do it, on and on, where I think you would have had a line drawn that did not result in endless litigation, but where states stopped short of these extreme gerrymanders for fear of getting overturned by a federal court, for fear of having the courts draw the lines instead. So I either Congress doing something, that would certainly be my preference on this one, and I'm not sure it's that big a reach, depending on where the Senate is on it. This side is quiet over there. There must be someone who's got their hand up.
Thank you. What do you see as the potential constitutional viability, much less political viability, of the National Popular Vote Compact?
So the question is about the National Popular Vote Compact, and a brief synopsis of that is it's a proposal to have states with representing 270 electoral votes. So obviously it'd be helpful if California, New York, Texas, et cetera, were in the compact to get you to 270. But the idea is that those states would agree among themselves on a compact. The Constitution actually says there can be a compact among states. Indiana is part of such a compact involving the water in the Great Lakes. That has been the sort of compacts that we've seen before. But the idea is that the states could agree, those states representing 270 electoral votes, that whatever the result of the presidential election is in their state, they would select the electors pledged to the candidate who had won the nationwide popular vote, so that that person would, through the mechanism of the existing electoral college, become president by getting a majority in the electoral college. Again, potentially meaning states have to vote against the way their own voters voted. Yes, the compact is there in the Constitution. It's never been used this way. I think I have practical questions, and two come to mind. One is, will the states who have pledged to do so, and they don't just pledge, they actually have to pass a law that requires the legislature to select the correct electors in that scenario, will they actually follow through? I mean, what happens if California legislature is required to vote for the Trump electors in 2020, in that hypothetical? Or, I don't know, the Texas legislature for the Clinton ones in 2016. Would they do so? Would they try to get out of it? And if they don't do so, what exactly is the enforcement mechanism? I get, I'm not a constitutional law expert. Clearly, the case would be headed to the Supreme Court, and assuming the Supreme Court upheld the compact and the obligations of the states, how does it enforce that? So those are questions that we haven't seen. I understand it maybe partially as a way to get people to talk about the Electoral College and to move the national discussion. It clearly would be cleaner if there were a way to amend the Electoral College, and that goes back to the earlier issue. If it turns out the Supreme Court says those electors are free spirits, then maybe there'll be a different discussion. But those are the questions that worry me when I think about what happened if they got to 270. I think they're currently at something like 170, and they've obviously got the low-hanging fruit, so it may be harder after that. One last one. I think is that about the right timing?
Thank you very much. One of the hopes that one sees expressed is that there could be a resort made to the guarantee clause, that the United States has to guarantee a Republican form of government to each of the states. Some people, what's been held to be non-justiciable before, I've read law reviews saying that it doesn't have anything to do about the democratic quality of the politics happening in the states, but it has to do with a kind of treaty-based 18th century, the monarchists can't take over in Louisiana or whatever. But there's a lot of discussion about that, and I was just wondering if you had any, in your own litigation activity, or any just theoretical thoughts about the use or not of the guarantee clause on these questions.
Yeah, you occasionally see the guarantee of a Republican form of government thrown into a redistricting case. I think you're right. No one is quite sure what it means. It presumably means at least representative government rather than aristocracy and a monarchy. But whether it goes to the quality of the representation or the way the representation is obtained, it's as good a theory as any to throw out there, but it's not one that so far the Supreme Court has bought. To me that there are a range of provisions in the Constitution that could mean something that haven't. So far, the court has not read them more broadly. That's certainly one of them. The one that I always looked at as a law student, and again the courts have looked less favorably on it, is the specific provision that says that Congress may override the states and make legislation on the time, place, and manner of federal elections. That's been read pretty narrowly. manner of federal elections? Why doesn't that include the way money is spent in federal elections, campaign finance, sources of money, et cetera? But that is not something that the court has found as an appealing ground so far of congressional action. But the point I was trying to make today is that there are always new framers and new interpretations, and maybe we'll have a court someday that looks at it and says, of course Congress has that power. It's had it all along. Thank you.
I would like to thank Mr. Potter again for an excellent conversation on behalf of ACS, the Bloomington legal community, and the students at Maurer School of Law. Thank you so much for coming to speak for our Constitutional Day. Right now, we're going to invite everyone to the lobby for a reception. Thank you again, Provost Rebell. So you can meet us in the lobby. And one more tidbit. If you would like to be on the ACS mailing list, you can see me, Trevor, or Mary, so you can get our emails so you come to more cool events like these. Thank you.